Any interim order is there or no interim order?
Not defects are not complied.
Well, the withdraw. That's all.
And they remove the defect within a week. And
Why you are not removing it, sir?
some documents.
Why? Some documents, the removal of the defect. When you file it, are you not sure that you have all the documents with you? What is the office note on the defects? What is the objection?
Need legible attested annexes.
Why you are not filing a legible copy of the petitions?
So at the time of filing, you have not gone through this.
Sir,
So if
sir,
you
there is a
could, read
system.
that.
There is a system which we also embrace there. That if it is somewhat illegible, then you can have a typed copy along with it. You can give a typed copy along with it if the photocopy cannot come. Give a typed copy. Yes.
Read and filed it.
The writ petitioner is directed to remove the defects as pointed out by the stamp reporter within a
Item 3 may kindly permit me to withdraw yours.
I best have the requirement to put at the law. Yes.
Item 4. 4 and 5 sheets. Similar but your copy not filed, madam.
Yes.
Plus separate copy. One case
Even a cost title is not in order. Wakalatnama is not properly stamped, executed, and accepted. Give me a copy. Let us see. What are you doing? So complacent in filing the petitions.
Many defects.
Multiple defects.
Sir, so sorry, sir. My case is 567.
Who is in for? Same order. In the event the defects pointed out by the stamp reporter is not removed within 2 weeks from date, comma.
Para 5 is not indicated.
What?
Actually, the question of the written sir.
Where is the?
That has not been typed by it.
Was title not?
Affidavit not proper.
Not proper.
Occupation not mentioned in the affidavit.
The occupation is the proprietor.
Orally you affirm.
Sir, what kind of an affidavit I do not know. Have you not verified each of the paragraphs which you have stated? You are a veteran in the profession, I believe. And it appears that you have a substantial years of practice. So what is this? First paragraph of the affidavit: name, aged about such and such, proprietor such and such, father's name such and such, number of proceedings High Court would be instituted, caveat no. This is the way affidavit is filed. Statement of facts are true to your knowledge and belief. I have not come across with this. the petition. You can't take it out. This is brother, this is the affidavit which is. File memo with liberty. Let's call the next.
Six, seven, we have copy is not filed.
Which one?
Which one, sir? Well, I have applied separate copy, the separate copy is not received.
That is not the only thing.
Second copy of the petition not filed.
Yes, I filed.
Affidavit is also.
I do not know.
There is a defect in affidavit also.
I do not know, brother, how to find out. These
Please,
are which are bold letters.
no. At the end, objections to be complied at the end. Yes.
Memo. Withdraw.
Withdraw. Item seven, withdraw.
Yes.
Item eight.
Item 8.
Question.
Withdrawing.
Yes.
Yes.
Item nine. Item 10.
I understand, brother. This is what.
Please, madam. Madam, here, this is a public interest litigation that to save the pollution, the spoil the entire natural atmosphere of the Hirakud Dam because allowing that ash pond warm that smoke by
GSP
the,
tribunal is there, I think. The green tribunal is there.
because the RDC and the collector has got the power, sir. Got the power, they can also take this only direction issue. If the atmosphere is going to spoil by they can also either to give some check, otherwise it should be shifted to some isolated place where they know that public persons are there.
In a public interest litigation.
Yes, sir. We all villagers adjacent to the Hirakud Dam, they are also affected because the outgoing smoke from that factory. That is the difficulty. We don't want to do shifting of that factory to say anywhere. Want to check that pollution out of the smoke.
Mhm.
Otherwise, it should be maybe taking some different day.
What's your stand?
Take instructions.
While your affidavit is a public interest litigation, 3 week, rejoinder 1 week, matter to appear after 4 weeks. Yes.
Sir, oblige, sir.
Until to 8th October.
Huh.
Item 12.
Payments have been made.
The payments have been made, madam.
What?
Money was to be disbursed.
Oh, yes.
Because this
Payments
is
have been made.
to be mentioned. Payments have been made as per.
So now nothing remains.
Yes.
Give. Give.
The relief certificate of the restriction has also been granted quickly. She doesn't want.
Second.
Sir, I have a repeated prayer. Annexure 1, the lease,
Why you limit your prayer?
at the present it is limited.
Oh,
Like quarry lease for sand mining was granted in favor of the petitioner in the month of January 2021. In the month of June 2021, so working permission was granted by the Tahsildar concerned to start the operation. But since there was delay in granting the working permission to start the mining, so I submitted an application to kindly extend that period. But no decision was taken. So after completion of 2 years, now the lease source was transferred to the mining department. Now my lord will kind on to annexure 6 at page 38.
yes.
Well, suddenly, though the lease was operating for 2 years, well, suddenly the mining officer stopped the mining operation that these are the 4 documents which are not available. Well, even though all those documents were available with the Tahsildar. So mining operation was stopped from 10/8/2023.
So,
Petitioner was requested to submit all these documents.
okay.
So even though Tahsildar was having that records were not produced, so I again submitted all those documents. Then under annexure 12, after submission of all documents under annexure 12, I requested the mining officer kindly take a decision so far as operation is concerned. That was followed by annexure 13 for extension of the period. Well, no decision has been taken by the OP number 5 so far as starting of mining operation is concerned. And also I submitted another representation under annexure 14 to the OP4 Deputy Director Mines to kindly allow me, since there is dispute with regard to dues for the 3rd year, kindly allow me to deposit the dues for the 4th year. And that is also forwarded by the OP4 to the OP3 Director of Minor Minerals, that is still pending. So these are my limited, this OP5 may take a decision.
What are you doing, sir? Why you are inviting those kind of writ petitions to come? Because this is what I find is a genuine case for consideration of representation. But with the caustic remarks.
one chance maybe given.
We will give a caustic remarks
Maybe fixed in during which time.
that he has flagged an issue. He has been persistently approaching the authorities. Authorities are not supposed to show their stubbornness in all respect. And what is the loss is there? And you go on making a demand for the whole year. You have stopped at one hand not to operate and then make a demand for the whole of the year. We have come across. You can't blow blow hot and cold at the same time. This is one of the example where we are making a caustic remarks on them.
I'll just take instruction whether any order has been passed pursuant to this.
To us,
I'll take instruction, my lords.
come on Monday.
Yes, ma'am.
We are not on your prayer. We are keeping it on a Tuesday. Keep it on Tuesday.
May make a small.
If it is not, just remind us my observations. I will make. Don't worry.
If we make a small request, my lords, this petition may be dismissed with the direction to consider this.
No, then we'll make a caustic.
No, my lords, only that to that effect.
If you want a disposal, but we'll make some observations.
Since March,
We'll make some observations.
receipt is there in March.
Yes, ma'am.
Now it is,
January release is going.
we are in September, more than 6 months, beyond 6 months.
And the mining operation is stopped. Just imagine. The Tehsildar issued an order to make the mining operationalized. Means the Tehsildar was absolutely convinced that all the formalities, norms, everything has been complied with. Now, because of the amendment having brought, simply the authority has changed, but not the incidences. If the mining officer thinks that this is what then it's a lapses on the part of the Tehsildar office that he is not forwarding or transmitting those records. How he can be blamed for that? Yet he showed his generosity and submitted those documents again. Yet you are sitting tight.
I'll take instruction.
Will it not invite certain remarks to be made?
I'll just take one chance, my lords, for taking instructions whether any.
Come on Tuesday.
Yes, ma'am.
Then to 9 September.
At the request of, yes, the direction standing. Place this matter on.
14, my lord, we have deposited that amount
To place some report.
on.
Instructions.
This is also
We got to representation details.
I've already deposited that amount my lord had directed. On 30th/8/19.
The interim order has to continue.
We are filing the rejoinder today, my lord. In the rejoinder today. Let it come on Monday, my lord.
Therefore, be pursuant to the
Of single tender in violation of the government.
That's where, as Secretary General, were directed to take instructional lordship. And or the municipal corporation has sought clarification from the government regarding award of the single tender lordship. The municipal corporation has not decided to opposite partners. Only my lord, financial bid and technical bid has opened. Since nobody was the participant for collection of revenue interest of the my lord institution, that is why the single tender and there was only proposal.
No.
So that
So yes, still that means you have not finalized the
Yes.
tender
municipal corporation has not finalized the tender.
as of now.
Yes, Lord.
My lord, there is a rule, there is a rule, OGFR rule, which has been
And the
amended.
government has not given his opinion on that.
Yes, sir.
Has given or not given?
Has not given.
My lord, there is a-
Why you're sitting tight? They ask for opinion from you that can they go ahead with the single tender? But you have to take a decision and then communicate whether to go or not to go, whatever.
there is a OGFR rule as is amendment. The OGFR rule, as per the OGFR rule, my lord, the single tender can be permissible with subject to certain conditions. So that rule
Let us-
probably,
What is this? OJ?
OGFR rule.
OGF.
May- may permit
OGFR,
It's
Orissa
OGF.
General
Okay.
Financial.
May permit to.
Which one? Volume 1 or 2?
No, it is amended. with-
Clause 6, can I give a copy?
When it is amendment? When amendment?
Amendment was done on
4/6/2025.
Oh.
Please,
OGF.
please,
Sorry, Lord.
Yes,
Please give.
Another copy. This is good.
this last paragraph you have extracted.
Para six,
The last paragraph
Thank you,
of
Lord.
your,
Lord.
my lord, that is at page 4. Rule 6, subrule Roman 22 of Rule 2004 shall be substituted with the following provisions. Lack of competition as mentioned in sub-para Roman 21 above shall not be determined solely on the basis of the number of bidders. Even when only one bid is submitted, the procuring authority may accept the single bid provided the following conditions satisfied.
So these are the 3 conditions they have to.
So probably on this basis, probably I hope they have sought clarification from the government.
Not clarification.
This is just a.
Yes, sir. The clause B also says that the procuring authority shall obtain the approval of the next higher authority
that's right.
on recording the offer following. So they have already moved to the state government for giving a clarification.
This one.
So this clarification has to come from them.
Government issued
This one, I'll just take
housing
a
and
copy of that.
Next, sir.
I think the Department of Municipal Affairs, who is the competent authority?
Director of Municipal Administration and HND
Housing
Department.
and Urban Department.
The urban, housing and urban.
This is the second page. Power.
This one.
But later on, they have amended. This was the 2018 letter. So they quoted, but this is of 2025 amendment.
Now, these ingredients they have stated 1, 2, 3 here. These ingredients which is listed in the. So in the second page, they have written taking into consideration their size and capacity.
And they are
to reach
saying that
out-
these are duly followed and the detailed information can be supplied to them. However, that is the old one.
You have, they have accepted
It's
the
a
single
contract.
tender. They have accepted single tender in Annex of 5 on 23/7/2025, but this letter is issued on 30th August.
No. This letter is issued, but the amendment was in the month of June. The
That was
amendment
council, that was council meeting, not commission has taken a decision.
This amendment
That
was
is why I have
issued.
sought clarification.
So they sought for a clarification.
We have not decided to.
Sir, you have unnecessarily created a confusion. So you have a legal department, I believe. This is which municipality? Cuttack municipality. Yes. You have a legal department? I believe so.
Your Lordship.
Every municipal corporation has a legal department.
Yes, Your Lordship.
Don't you know that a letter issued by a government or a department at the pre-amended stage, if it runs contrary to a subsequent amendment having brought in the statute, then letter automatically goes. And you have flagged and there appears to be a contradictory nature. It's an automatic supersession. Right? D'accord. At the very outset, we must
Same what the sub-item as well.
Oh, in view of the judgment delivered.
May please.
Yes.
Subsequent this matter, the technical bid of the petitioner has been rejected on the ground for non-verification of the documents. The documents were not verified as the same was snatched away by the other tenderers, and for the same the petitioner has filed an FIR, but the same was not considered by the tender committee, Your Lordship. The
When
rejection,
FIR was lodged on the same day,
yes, Your Lordship.
same time,
Yes, Lordship. The rejection is at page 96.
how can you not control within that particular office?
Yes, no, Your Lordship, outside. After the pre-bid meeting, when the petitioner came back, was traveling back, the documents were snatched away. On 1st of August, the pre-bidding meeting was held. On 2nd, the document verification was to be done. On 1st, Your Lordship, while returning, the same was
Have you
snatched.
named the persons who have
Yes, Your
snatched?
Lordship.
Any interrogation was done?
My lords, I have to take instructions, my lords, and also my lords, in this matter, notice has to go to opposite party number 2, who is the tender calling authority, my lords. Odisha State Civil Supplies Corporation.
Did you intimate them on the same very day, the tender committee?
Yes, my lords, that is.
That look, I was traveling from your office
Yes, Lordship.
after submitting the bid,
Yes, Lordship. On 2nd, I have intimated them. On 1st, I have registered an FIR.
and when the verification was supposed to be done?
2nd, Your Lordship, 2nd of August.
First, you went to the office for what purpose?
Pre-bid meeting, Your Lordship.
So there you showed certain documents or not? No.
That if document verification was not done, Your
Then
Lordship.
why you are carrying a document with you, original?
Your Lordship, as he was traveling, so he had carried all the documents with himself.
As he was traveling means? Only a pre-bid meeting means only the oral, whatever, the modalities or something is to be done.
It was stated, Your Lordship, he has taken, if at all, the document verification could be done on that day, Your Lordship. He had taken.
He has not, whether the date was fixed, second was already fixed prior to first, or it was fixed on first for verification. Then why you carry?
Your Lordship, he is the representative of the petitioner, Your Lordship. He had taken by the tender, Your Lordship.
Take instruction.
Yes, my lords, notice to opposite party number 2 is the tender calling inviting authority, my lords.
Are you not in a position to represent them?
No, my lords.
Why?
My lords, I can take instruction from the collector who is the heading the tender.
And tender finalization or finalizing committee, who
He's
are
headed
all-
the collector, my lords. I'll take instruction, my lords.
there?
My lords, what
Why the
documents
notice?
are verified or not to that effect, my lords.
Sorry,
This is.
they are all the organs of the state. Is there any person or of the committee who is not associated with the government?
No.
Then
It's only because the tender.
unnecessarily, why can't you represent? You can represent separately all of them, but not collectively. Just in. No issue. Take instruction, come on witness it.
DLO, DSWO, RTO, ADM.
All the government. That's why I say, if they are individually made a party, you can represent. But collectively, you can't represent. Issue notice.
Collector approves it.
An IA has been filed.
Let the IA be there. That's the second of.
August, no?
So 1 month, if you can wait for 1 week more. Yes, next.
Then to 10 September, item 17. Last 40 years, the shop is operating.
40 years, the shop is?
40 years, last 40 years,
4 decades.
4 decades.
Yes.
Shop is operating in the same location, same premises, only by way of change of licenses from time to time.
So you have, I think, saturated the entire inhabitants of your locality.
That,
More than his
subject to-
age,
Huh?
more than his age
subject
of
to-
doing business.
subject to locality being accustomed with it.
That's why I say the saturation now, everything.
At
has-
the age of 13, he started his business.
At the end of
No,
13.
no, he's forgetting.
30th,
13,
13th.
who is a deponent.
Acha.
So now he is 53. You said more than 40 years.
He said by change of licensing, Lord. From spade to spade, licenses are being changed, but shop remains same, location remains same. Because this sometimes tender is taking place, sometimes lotteries are taking place, licenses are being changed, but shop remains same, location remains same for 4 decades. Today,
So it was a collective effort of
all the
fulfilling all the demands
yes,
of
yes,
the
the
people.
people in that area, they say that this should be here.
Yes.
That the collector and superintendent suddenly, Lord, like a bolt from the blue, they say that you shift it to some other location. Annexure 1 is the order. Collector has no jurisdiction, superintendent has no jurisdiction. Then if you Lordship see the grounds assigned here, Lord, absolutely unspecified ground.
Yes.
And if you Lordship see rule 40, section 41 proviso, is as the licensing. Yeah. They become successful in 2021 lottery. And at least from 21, by now it has completed 3 years. Provided to section 41 says that once a shop is allowed to operate for 3 years, normally an objection should not be entertained for 6 years.
Normal or ordinary?
But this said, provided that, you're not so I'm sorry, ordinary, I'm so sorry. The language.
Those countries do different meanings.
Right.
Ordinary and ordinary.
Yes, ordinary. I stand correct. Ordinary.
Rule 41.
Section 41 provided. Section 41.
Yes. Is there any special reason?
No. Only thing is that, as you may see, that it is written here regarding existence of shop in close proximity of PHC, temple, educational institution, etc. No specified distance is mentioned here. That too, nothing is indicated who has these are PSC temple. Last 40 years they are there. Last 4 decades they are there.
That is, if there is any subsequent changes. So for that, topic of is concerned or.
Upcoming of temple, upcoming of new temple. But that's also not said here.
Or any, what is it? Yes.
PSC problem, public health center.
That we have been set up.
But that is not said here, but then,
Of the pressing demand of the need,
right.
or maybe because of your existence.
But that's not specified here, but then in any view of the matter, this will not apply to me.
I said.
Right.
Here, what is the
Public health center.
to those where inevitable demand, pressing need, or an urgent need because of your existence.
Yes, that may be, but I agree. I agree. Teetotal. Yes, I was appointed as the.
And I was that in order.
I have submitted.
was passed in DIA.
Yes. I have submitted a thesis to the government. How the de-addiction, I have visited nook and corner of the state. de-addiction centers I've seen. I have seen their condition. How are they? I have suggested how to improve it. I have gone to schools, how the children should be registered from all this. But one paperwork is given to the government and they are working on that.
Yes, madam. But we have to see about proviso to subsection of section 1.
My lords, in this matter, a counter has been filed, my lords.
How you have dared to wish to.
Yes, my lords.
What counter?
My lords, we
Yes, says that unless there is a very strong and special reasons are recorded in writing.
yes,
First thing is in a counter show, this superintendent or whatever, the collector, have they recorded as strong reasons, special reasons.
yes, my lords, there was an inquiry done thereafter this order has been passed, my
I
lord.
am asking when the requirement of the statute, the recording of the special reason in writing.
Yes, my lords.
Was here, it's recorded in writing.
Yes, but it's-
I'm just asking.
If you may refer to annexure 1 only, my lords, the impugned. Annexure 1 of the report. Yes, my lords, 53, my lords. Yes, my lords. Yes, my lords.
Which shows annexure.
My lords, first, my lords, if I may refer to annexure 1 to the writ petition, only, my lords, the impugned order, my lords. Page 11.
So why not this started with A4, it was wrong.
My lords, this was already.
Counter.
3 and 4.
Where is the letter?
My lords, first, if I may refer to annexure 1, page 11, my lords, the impugned order, writ petition.
Yes. Yes.
Yes, my lords, if I may read the second, first paragraph.
Correct. Yes. Going through the Avijo.
Filed by
Yeah.
Mr. So-and-so against the functioning of so-and-so IFFL off shop in an objectionable locality and report of the inspector of the excise, Paradip, regarding existence of the shop in close proximity to PHC, temple, educational institution, etc., causing inconvenience.
And the special ground is that particular shop is in existence since last 4 decades.
Well, it's-
And then when you submitted and granted the license and continue to grant the license for 4 decades, did you not take into consideration that there is a PSC, there is a temple? And then the distinct norms have also been introduced. Has been indicated that there is a distance norm. Secondly, if there is no, if the objection is raised after 3 years, then
Special.
section 41 provides that
Yes, my lords.
has to be taken into account.
Yes, my lords.
Then what is the account? Nothing. Government intend to grant exclusive privilege.
Yeah, my lords, the direction has been only issued for shifting of the shop, my lords.
How can you, on the basis of the special reason?
Yes, my lords, if I may refer to the inquiry report, my lords, page number 13 of the counter affidavit. Annexure B by 4.
Yes.
The distance and all is mentioned in 4th paragraph, my lords. Second, 3rd and 4th, if I may please, my lords.
You will see in this third paragraph,
I have seen,
rule 20, yes, 26 is
Rule 26.
not applicable. They have admitted.
I have a
Yes, yes.
worry about it. I know, my eyes stuck. Oh,
Yes.
there, this is- yes. How can it be? That was in relation to option.
Yes.
What about option?
There's a distance, my lords, only to.
I'm talking about the distance, the exclusively applicable to.
My lords, rule 53, my lords, of
You are
the,
talking about rule 26.
my lords,
The authority has noted 26 in rule. What 26 is?
26 rule 26 deals with
Consumption of the liquor within the greatest premises. Also. 100 meters norm comes with on shop also. If I went to 300, 500 meters, everything these norms comes here. That is all option.
and it's rule 53, my lords.
Fifty.
53, my lords.
Yes. Does not talk about any distance from.
Well, it does not specifically talks about the distance, but
You then change this provision override this 20 provision of the act. This rule is playing in exercise of the power according to the perimeter. If the perimeter says that ordinarily no objection on any corner will be ordinarily be entertained if after 3 years, if it comes after 3 years, then unless there is a special reasons to be recorded, is a special reason.
yes, my lord.
Villagers have objected 100 meters norms, 300 meters norms, which you are citing. They are applicable only to on shop license, not off shop.
Object only because the objections were raised and that
Can
hence
you, then why section 41 of 1 or whatever it is provided that no objection, just negative value
yes, my lords.
shall ordinarily be entertained for a shop continuing in an area for more than 3 years.
Yes, my lord.
So they are admittedly continuing for last 40 years. Only exception is unless there are special reasons to be recorded. Where is the reasons recorded in writing? Special norms. This is special.
Only the
Applying a provision which is inapplicable is a special reason.
only reason which is applied in the
You have to follow.
my lords only
You have to follow.
if I may request my lords to
Which argument is referred to?
yes, my lord.
That is based on different context altogether. I'll come to page 24.
Yes, my lord.
Uh, 5 to 6 line below. If the
Concerning a new shop.
and proposed outcome. Perhaps to come in context is something with that. Page 24.
My lords, if I may make a
Page
small
level of that document.
small
You have
yes,
exposed to this counter.
Let's if I make a small request, my lords, this counter, I just received it, my lords. If it may be taken up on Monday, my lords, I will be well prepared, my lords. Monday, my lords, only request.
Not now. Yes.
My lords,
If the authority has spoiled the counter, they have to stick to what they have needed in the counter. Further instruction
no, it's not further.
is not warranted at all. We will go by what you have stated in your petition. No.
No, my lords, no
This is
further.
giving a premium or giving a, I'll say, laxity to the government.
No, my lords, no instruction, my lords. I will be better prepared, my lords. I just received it, my lords. That is
When you are filing your counter.
this, my lords, is not.
For giving first paragraph. They wanted, since was the notice where they have inserted and also close down the proposal for the opening of the offer. Yes. This is even more there. Because the starts with the 60. Because something matters. Yes.
My lords, small request, my lords, because my lords, I have not filed my lords.
What?
On Monday, my lords, I'll just go through it properly, my lords, only to assist your lordship.
The matter which could have been disposed.
Yes, my lords, I understand.
Nothing of that is being Is giving a just putting a matter into a ventilation.
Well, only Monday. Monday, my lords, first item, my lords, I'll go through it properly, my lords.
First. One of the.
An IA for amendment of the writ petition. Yes. But clause B, IA for amendment is there. Yes.
Yes, madam.
Yes, your lordship, the copy may be given.
Also amended the prayer portion.
Yes, yes. Yes, ma'am. One prayer I have added.
Yes. What I do.
Yes.
Yes. This is.
Yeah, please. In the case, my lord, the technical bit of the petitioner rejected on the ground he appropriated the busy and exemption, my lord, and paid for pray for exemption. My lord, no, not self. Lord, he has a clause 34 provides for submission of bid through busy, my lord. No, my lord. I am bank guarantee submitted. Bank guarantee submitted under clause 34. they receive the bank guarantee. They say under the e-procurement you claim the exemption but submitted busy and you are registered your lordship at direct to stage of bidding of the.
No, but incorrect facts are placed before my lord. Yes, my lord. I would rather say misrepresentation of the clause, my lord. If your lordship will refer to page 49, the 49, page 49, page 49.
Yes, your lordship.
The clause my learned friend is referring to, that is 34. The bidder tenderer whose bid has been accepted will be notified of the award. Then the second clause, if your lordship will see, the notification of award will constitute the formation of the contract subject to only. So these particular clause refers to the bidder whose bid has been accepted and award has been given effect. Now, what is the correct provision? Yes, he is referring to that portion. Yes.
Plus the initial security deposit.
Yes.
Slash any other security deposit can also be taken from the contractor in the form of NSC.
Yes.
That's post office saving bank, post office time deposit account, charge transfer from bank level.
Yes.
In favor of the original from any nationalized scheduled bank. India. From the guarantee by its local branch of the government for the
The procedure for e-procurement, your lordship will kindly see page 27. I'll just show my lord 2-3 clauses. Page 27, clause 3, your lordship. This is a part of the invitation for bid. Clause 3, the bidder shall transfer online the earnest money deposit bid security of the amount specified for the work in table 7 column above as per the part its bid through process mentioned in the DTCN. Now, my lord, may kindly come to the DTCN. The DTCN starts from page 46. I'll take your lordship to the relevant clause at page 61. Clause 122, the eligibility criteria.
Yes.
To be eligible for qualification, applicant shall furnish the following documents: required EMD bid security as per clause 6 of the DTCN. Now, my lord, may kindly come to page 46, clause 6. The bidder shall remit the EMD bid security online as a part of the bid of the amount as specified in the contract data. Then your lordship may kindly come to the procedure. The procedure, your lordship will find at page 32, procedure to participate in online bidding e-procurement. Page 32. This is the procedure to participate in online bidding e-procurement.
Yes.
Now, my lord, may kindly come to page 33, subclause subclause 2, the clause 2, my lord. Payment of EMD, bid security, and cost of bid documents. Then your lordship may kindly come to 2.1. The EMD and bid security payable along with the bid is 1% of the estimated contract value or as mentioned in the bid document. Then 2.5, your lordship may kindly see. Government of Odisha has introduced e-payment gateway into the portal for payment of cost of bid and bid security earnest money deposit. The process of using e-payment gateway is mentioned in the procedure for electronic receipt, accounting and reporting of cost tender paper and earnest money deposit on submission of bids. Now, this procedure, your lordship will find at page 40. This is part of the tender document, page 40. May I take your lordships to clause 5? of page 40. Procedure of bid submission using electronic payment of the tender paper cost and EMD by the bidder. Log on to the we are not concerned. Then straight away your lordship may kindly come to clause C of 5. The electronic payment of tender paper cost and EMD. Then the bidders have to select and submit the bank name as available in the payment option. A bidder shall make electronic payment using his or her internet banking enabled account with designated bank or their aggregator banks. A bidder having an account in the bank can make payment under NEFT RTGS facility of designated banks. So this is the procedure which is prescribed. He submitted the BG, which is not the prescribed procedure, my lord. And he not being an engineer contractor, he doesn't fall under a exempted category. So under two conditions, my lord, his bid has been rejected. And in the meantime, my lord, the financial bid was supposed to be opened on 14th of August. Now 14th of August, 26 persons qualified for the financial bid, out of which 24 persons bid was quoted the same price. There was a lottery, and in the meantime, it has been finalized in favor of one Jagdamba Construction, and subsequently it has been sent to the government for approval. This is the instructions. Yes. Work order, it has been sent for government's approval. And that clause 34, which my learned friend was referring to, that is in respect of earlier, that was the practice that they used to submit the bid in a box. This e-procurement system was not there. So that clause, although it is being repeated always in the tender document, but e-procurement is the procedure right now. So that particular portion only refers to the successful bidder whose bid has been accepted and the contract has been awarded.
So at this, and if the event is declared as the bidder,
Yes.
then he can substitute that EMD by way of a bank guarantee. It's a big money which he has personally.
Yes. 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 Yes.
My humble submission, sir, there is no bar in view of the clause. There is admittedly electronic procedure, is the online tender. 34 is the clause. 34 is the part of the bid document. You also can 34 says
You are relying on this, that the EMD also can be done.
exactly. Yes, Lord.
Now, one, I think what we say that you have to harmonize this problem.
No.
So you can't make it to that sense. So it can be done, but what stage? See, after the declaration.
No, EM always.
If a tender has been successful, then he can at best substitute that EMD by way of a bank.
That is not clause safe. The rejection, your lordship.
Then if this clause comes, if you read the clause, what is the meaning of this word? It is down to
This page 49, your lordship.
if you come to clause E, for a cheap, very good.
Plus the
Because it is 33. The declaration will be dealt with as per the terms and conditions of opening.
your lordship.
Now, the bidder or tender whose bid has been accepted
Your lordship.
will be notified of the award.
Yes, Lord.
That means your acceptance is notified by the engineers prior to the expiration of the validity period by cable. The next specified confirmed and registered letter means you are now adjust as the highest bidder. This letter, hearing after as in the condition of the contract or letter of acceptance, is sum that the engineer will pay the contractor in consideration of the execution, completion and maintenance for the job by the contractor as contractor. The notification of an award is what it says that it has to be notified first. The notification will constitute the formation of a contract. Once you are adjusted as the highest bidder,
Yes, sir.
that means they have to notify that the, that you have been appointed a contract. Formation of a contract subject only to.
Yes, Lord.
Formation of the performance security. That is initial security.
Your Lordship, distinction two part, your Lordship, clause 34 is two part.
In the form of NSC such and such, saving deposit, such and such, in favor of the principal from any customized bank. Right, that is the performance security, you have to give letter of.
Letter, yes.
Digital signatures and such and such. Then it's EMG, which were.
Is, your Lordship,
That's initial security deposit, this is also,
your Lordship.
they talk about. And then any other security deposit may also be taken from a contractor
Yes,
in the form of NSC bank guarantee
your Lordship.
in favor of the digital engineer from any national bank.
Digital document.
Such and such. So this is how they say the EMD was, they use the word EMD, you are saying that EMD means that they have to.
Before bidding.
Give the bank guarantee.
Yes.
We say that you have to harmonize, that's clause 34 comes into play. Only when you are adjudged as a successful bidder and there is a notification of an award to be passed in your favor.
Yes, Lordship.
Then you can substitute it because you have to work and you need a running, the money.
Yes.
You need a continuous flow of a money to execute the award. So instead of that money being deposited here, that can be given it to you as the running capital. And you can publish a bank. In those days, it was not. Bank used to collect only a certain percentage of the total bank guarantee. Now, distribution is because he says it will come only when no tender is accepted, but what is awarded.
Let my humble submission, your Lordships. The 34 is two parts, my Lord. One is, my Lord, deposit of performance guarantee is segregated, my Lord. Your Lordship, they say that before that you will appease.
First sentence, the word expression which is used in clause 2, which you are referring. In the first sentence says, the notification of an award. What, when will this notification of an award be made?
Yes, Lord.
There.
Post completion of bidding. Yes, Lord.
So at the pre-notification of an award stage, you have to follow the other.
My humble submission, your Lordship, there is a full stop. The EMD.
The full stop means this has to be in conjunction with this. You can't segregate as per your own wills.
Millard,
You can't segregate.
Millard, your Lordship. Millard, my humble submission, your Lordship. Recently, Millard, after this, Millard, the tender, they have modified that clause. Your Lordship, have given. But this is the part, your Lordship, can have one document. Your Lordship, they have, your Lordship, can you see? Your Lordship, kindly, since there is a 34 existing, your Lordship, the serial number 1, which is mentioned the EMD word, they subsequently 16th August, they modified it. Now they have, my tender was in 34. So I cannot be, your Lordship, kindly see the, and
What is the modification?
your Lordship, your Lordship, second time, Lordship,
Only
modified as current
that
agenda.
portion has been deleted.
Deleted. Exactly, Lord. The
So
second
that
part.
portion deleted.
The redundant portion was.
Yes, deleted.
So the subsequently deleted, Lord. So at the,
That will not want to give you back the money. Or substitute whatever with another goal of security. So they have, that's the.
Millard, I participate in five.
Has to harmonize. That with the earlier clauses, suppose if there is an inconsistency between an earlier clause and the letter. Or the clauses in a different part of the contract of the tender, which will prevail.
Always, Millard, there is no.
Under the interpretive tools, what to interpret the clauses of the contract,
Your Lordship.
what should be the course of action is the court should adopt. If the court finds inconsistency between the clauses,
Your Lordship.
then we should prevail and we should not prevail.
According to my lord, the object of the tender condition.
Is the primary object is the in procurement.
I uploaded in procurement, but bank guarantee. Your lordship rejection order. Then my lord, then your lordship last commission, my lord. Your lordship further still case, your lordship sir, the for this principle of further the object to be to get the EMD. Principle of I am subject to further still.
What is about it? Because I'll tell you the reason behind it. The reason was that you need a running capital to execute a work. And if the cash money is deposited by you, that money got stuck up. So they were under the impression that if you give a bank guarantee, which secured their interests, then in that way, this capital, this the money which was deposited may be returned to you so that you can use it as a running capital. That is how the harmonization has to be in the system. Now they say no, itself because those era when it was introduced, if my experience goes, many banks from those era, they used to issue a bank guarantee with certain amount. Only the 40% of the total bank guarantee. So one has to pay less to the bank because of the solvency the bank has pursued. But now the scenario is earlier guidelines says full amount.
His figure is not dispute, the beneficiary name is dispute, not dispute. Only instead of online, he submitted bank guarantee through online, my lord. That is, my lord, that is the my lord. Only, my lord, my humble submission, my lord. 34 was deleted, my lord, subject to last submission, your last two submissions, my lord. Subject to consideration, your lordship. 34 earlier is there.
Because they perceive that the argument from your engineer brain has come. So they wanted to avoid it.
Number two, my lord, the object of the once is there, you can't, my lord, subsequently change. Number two, my lord, the further still case.
This was coming under what law? Is a procedure.
Is it 34, your lordship?
Clause 30.
That 34 is the, my lord, your
Is
lordship.
that
Detailed tender call notice. And here, it is a my lord, detailed tender, my lord, two distinction, my lord.
What was the last date of the submission?
My lord, this last date of submission was. I'm submitted, my lord. The last date of submission according to tender notice, my lord.
5/5/2025.
5/5. And my lord, I may be, my lord, very clear, my lord, this notification is not related to other tender, not related to this tender. They have, after this, they have, I participate, they have deleted. All the now state deleting this clause 34. Because at the time of bidding, there is a 34(2), my lord. I participated on the impression that BG will be accepted, my lord.
Where is the date, last date of?
My lord,
Your-
page 30.
Yes,
Page 30.
Which does not form part of that particular detail in the law.
Yes, this is the part. Yes,
Oh,
sir.
looking in a different perspective. Looking in a different perspective. Now I will tell you why I am looking at. And what I am looking at. 30.
Page 39A. Bid
Oh,
info.
there is a equities bill. Wait, 30 is 27.
Page 27.
Now, he has been given. Yes.
Page
Now,
paras.
this is me.
Yes, sir.
And it will be open.
I participate on 4 years.
And then it contains a several documents. This is the checklist also.
Yes, yes.
And then
Contract data, my lord.
contract data is also given.
Yes, sir.
Then procedure for execution, online is also given.
Yes, lord. It is clause 4 provides security bid submissions, my lord. Page 36. Same. Lordship. Of the 2-3 parts of bid document, 4A of
This is the procedural part,
procedure.
the procedural part,
Page 40, Lordship.
page 40.
Yes, sir. That is admittedly there is a procedure of accounting,
So this is what is there.
and there is also 34, my lord. There is 2 clause, my lord. 34
This
is
is what I am talking about. That there is, this is also coming under this clause.
yes, Lord.
This is the procedural clause talks about. Then the detail in the tender form notice.
Page 40.
It talks about the detailed tender form notice, means how it has to be done.
Page 46.
Oh,
So once
one in the third.
172 only plus. Page 72. This is what is the stage of online when you are downloading document? One vanish, I have given an example of the my tender of other work, case 72 million. You are paying EMD through bank guarantee. This online procedure, can you see? The word through bank guarantee slash tweet transfer exempted EMT. The option is provided to submit EMD through bank guarantee. So, my
Related to this document.
it's related to e-procurement tender procedure, not related to present package.
So,
But I am giving example. I cited to him also that because after this uploading, this page, next page will come. That is my humble submission. That too, because there is a method you are going accepting EMD now saying that, and the rejection order you also one page one rejection order is your also page 23.
Made a bank guarantee, you have not made the amount.
No, they say, my lord, the bidder has applied for exemption. I never applied, I am partnership firm of EMD in the e-procurement portal and uploaded BG as supporting document. From RC, it is seen that the bidder is not an engineer contractor. Hence, found to be non-responsive as per DTCN clause C6 due to non-submission of EMD. Non-submission of EMD. Case 23, my lord. This is the rejection. So, my lord, that is, my lord, rejection. Online they are accepting that the 5 tenders.
But this has not been, if your lordship will see, page 72, he is referring. My tenders EMD exemption. That is at the top. My tenders EMD exemption. He claimed for exemption, not being an engineer contractor, he claimed for exemption. So while the authorities, while rejecting, if your lordship will kindly see the technical bid proceeding, that is at annexure 1. Annexure 1 is the proceedings of the technical evaluation committee meeting held on 8/8/2025. That is page 20. But it is only, it has to be.
Only will not do. About the last day of submission is over. The person who was found to be qualified or eligible to participate. If you change the particular eligibility criteria or a particular condition subsequent thereto, then the court will be spectator will disregard.
Well, here only the documents are uploaded, but it is evaluated as per the proceedings.
Suppose the eligibility criteria that once you make an application for procurement of this particular contract, you should submit the certificate issued by, say, the local issued by authority below this the engineer in charge. Like Corinthian will say that the certificate must be filed in engineering firm. So a person was eligible when he submitted the certificate by the officer below in the rank of engineering firm. Subsequently, you change the criteria, which makes him ineligible. Can you do it?
No criteria has been changed, my lord.
This is what a criteria. According to him, he was one of the conditions for the purpose of submitting the bid. Subsequently, you deleted that particular portion by way of a corrigendum, which makes him ineligible because the BG is not considered to be a criteria.
But that corrigendum was, the corrigendum my learned friend is referring to, although that clause is not applicable, but still, even accepting his argument. But that corrigendum.
Whether the clause applies or does not apply is a different
Yes.
scenario.
But that corrigendum was issued only on 16/8.
But he is deriving an inference that clause was since operative. Stage of submitting the bid also. So you thought it bid that it should be deleted. You deleted.
My learned friend is referring to only clause 34 and wants that every other document, other procedure which has been.
Say that it is for the stand that clause 34 does not apply at the scheme of submitting the bid.
Yes.
Then what was the officer not deleting that particular portion?
It was deleted because although it is not in my instruction, Why they have deleted? Because that was the earlier procedure when the tender documents were submitted in a box, and there the I mean the bidders were asked to submit those documents enclosing like BG and other things. That procedure was earlier there. So that old clause has just but it has been deleted right now. I'll not say the no because he has come up with the notification. But this even this deletion or the clause being there under 34. Yes, corrigendum delete.
Criteria
Yes,
for making application
yes.
is substantially.
But why they have changed? Because why they have deleted it? Why they have deleted? Because once through e-procurement system, a bid is submitted by the bidder at the very first stage. There was
This document. You are improving your case at the bar.
no, my lord, I'm not improving. My lord, if your lordship is
Whatever.
That's the problem.
yes, lord.
May beg your pardon, Lordship, item 34, your Lordship, hearing has been closed about a month back. It has come, that is. Last time also it had come for ours.
Make it small, sorry, can I make it? Such matter would it be convenient to take up that one matter actually supposed to be listed yesterday and, the difficulty this board had. That is item. Yeah, I know. Therefore, I'm not saying anything. Item 32 is that item. Yes, if the health doesn't permit or anything, definitely I'll make it. Yes. Very well, very good. Some date can be. Very well. Please.
Your Lordship, item 32, my lord. Very fast. No, my lord, they already filed the affidavit indicating that 3 persons they are going to give the appointment. Imran. Then your Lordship start that, my lord, because last 10 years we are waiting. At least.
Let us, not. Yes, sir.
The technical bit of the petition is rejected on the ground of non-formation of the original documents and remain absent at the time of opening of tender, my lord, which is reflected in page 108, my lord. Page 108 of the bid, my lord. This is the technical bid evaluation in respect of Hasipura block. Column 6, my lord. The petitioner is Pradeep Kumar Muduli. Absent, not production of original documents to the scheduled date. My lord, page 108, column 6, Hasipura, my lord. My lord. Third one is, the petitioner is the third one, my lord, Pradeep Kumar Muduli. Absent, non-production of disqualified for non-production of the original document. The petitioner could not appear on the date due to his illness, my lord, and he has approached the authority, and for the said unit, the tender is not finalized till date also, because nobody has qualified in the tender. For that reason, they have stated that we will go for fresh tender. Oh, I am not a single bidder, my lord. Maybe as per the guideline, guideline means first attempt it is no, in second attempt it will be considered by the authority. My lord. PWD code that is yes, my lord. I am conscious about that. I am conscious about that. Only prayer is because he is ill, for that reason he has approached the authority. Yes, my lord. Everybody is disqualified. Your lordship, if my learning friend will take instruction whether they.
You do pursue or will you pass on? You have to reject the petition. That's why we say, you like a rejection or?
Only I pray if your lordship permit my.
The next time?
Yes, madam. If my lord. If your lordship give a chance, if they will not go for fresh tender till that they have not plotted any fresh tender, madam.
They can go for a fresh tender.
They have not plotted till now, till filing of the writ petition. Yes, madam.
Yes, my lord. Your lordship only, I may be, I may be permitted to withdraw with the liberty if this cause of action survives, then I. There is someone, if they will not protect the fresh tender, my lord, then I can approach the court also.
They are not proceeding.
Because till now they have,
are concerned with this trend.
yes, sir. But they have not floated the fresh tender, though it has been written. Yes, ma'am.
Yes.
Yes, ma'am.
Yes, next.
Both the matters are for 2 blocks. Same bidder, 2 blocks that has not been finalized due to non-application.
Lordship, me pass it over. Miss Das is on her legs now. Miss Das, Aishwarya Das. Item 21.
Your Milk, that vendor matter. I was selected, I was qualified first time.
Where is she?
She is with the Advocate General, assisting the Advocate General, ma'am. Here, your lordship, you've got the instructions. You may file a affidavit, your lordship.
This letter that is looking for.
That page 32, your lordship,
On PBT,
disqualification.
there
your
is one.
lordship. That the bid has been disqualified for suppression of fact as per clause number 2181 of DTCA. 81 of DTCA.
That is, no,
The question of fact as per clause 2.1. What is this?
that below my home submission.
Where is that clause?
Clause. Page 57 below. 56 below, my bid.
56.
That is 8.1 to 8.81. Even though the bidder with the above qualifying criteria, they are subject to be
Where is that?
57, 57, 57,
Where is that?
57. Page 57. Yes.
Yes.
Yes, yes, that is. That is the reference. For suppression of that. That suppression of that is that voucher showing purchase of shutter plate. That was that. Yes, that was ignored by your lordship. That was ignored by 156 page instruction from the yes. Redundant.
Yes.
That-
Reason it
yes.
was kept there.
Yes, your lordship, and that.
It is not a requisite document.
Yes, no.
And the authority has said that it has to be ignored. Even if he has given a surplus document, but that cannot help in this disqualification.
Because that fabricated documents were from Upendra Steel Industries.
Yes. The voucher is prepared by them. Right? You have an issue that this voucher may be fabricated or something. But that voucher is not a condition to speak. Can you make a disqualification? Because your circular is that no voucher should be taken into account.
Yes.
Ignore.
Ignore.
If you are supposed to ignore, then you get.
Your lordship, he's given here what my instructions are there. He's given in an affidavit that the facts stated in the affidavit are true to the best of my knowledge and belief. And then he's giving some vouchers and which are false and fabricated because they are from Upendra Steel Industries. So the committee has put a question mark on his intent. That is all, your lordship.
If we want, is the effect of a suppression. The effect of a suppression is to have some meaningful gain.
Yes, your lordship.
If it does not contribute any gain to you, because that voucher, according to your own decision, is not required.
Yes, your lordship. That is there.
Then what gain?
Your lordship.
What gain? Nothing.
Yes. Page, Article 9, page 156. 156. Issued by the opposite party, the apex authority. Page 156.
156.
Yes.
So see that it should not be considered for technical bid.
Yes.
Yeah. The bids submitted by the May I please your lordship? May I please your lordship? Lordship, Mr. Naik, conducting counsel, is on legs. Mr. Naik, conducting counsel is on legs on arbitration matter. May I pass over matter, ma'am? Thank you for the follow. Of the finance of the lordship was covered under your lordship's order. Consider. Hello, my lordship. Please, your lordship, it's in registration cancellation. RC cancellation.
Respect on the Orissa Sales Tax Act for the period 1997. Here I have challenged suo motu revision of initiation of suo motu revision and order passed by the sales tax officer. Sorry, additional commissioner. Brief fact is like that. There was a initially assessed me under section 12(5) of the OST Act on in the year 2002, and against that I filed the appeal, first appeal, and against that I went for the second appeal, and after second appeal, matter come to this honorable court, and this matter was pending. In the meantime, another demand has come up by the Bhubaneswar. This is regarding to Cuttack Circle. The main dispute is that the rental collected by the BSNL, monthly rental, whether it is come under the right to use or not. So again, another demand come up with the Bhubaneswar Circle, demanding 171 crores under the VAT Act. That is for the period 2010 to 12. So that matter we have directly challenged before this honorable court by WBC number 16645 of 2014. So that kindly have a glance to that order, that is Annexure 6. Page 77. That relevant is page 80. By way of this writ petition, petitioner has questioned the validity of assessment order dated so passed by the Deputy Commissioner Sales Tax Bhubaneswar 2 Circle under section 43 of the OVT Act, imposing tax penalty as well as jurisdiction of the Deputy Commissioner imposing VAT on transaction which does not transport to right to use. The Learned Counsel for both the parties jointly submitted the issue involved in this has been settled by the Supreme Court in the case of Bharat Sanchalaya Union India in writ petition number 2006. And hence, Mr. Misral and standing counsel for the department state that matter shall be remitted back to the assessing officer for fresh assessment in view of the decision of the Supreme Court. So, this matter was remanded for assessment. This is related to that is for the VAT period, like 2010 to 13. And that in pursuance to this direction, the assessing officer passed the order that is at page 82, Annexure 7. The very exhaustive order, and they hold that whatever the it is purely there is no right to use, it is purely service. Kindly have a glance to page 105 in the assessment order. That is 31st March 2021, the order they passed, the assessment order. Their observation is at 105. That is at 106, that is 0.1, that is fixed monthly charges are entered. In first paragraph, they have highlighted the right over the implements instruments never transferred to the subscriber, but only telecom service are provided through the complex telecom service. And finally, they hold at page 107. and got at page 107. Above question is that there is no transfer right to user. And after rental and fish only charge. Yes. So they admitted that there is no right to. Subsequent to that, in the meantime, there was around 80 matters pending with all East Circle. There are 13 telecom district circle. So that I have given the list. That is an annexure 21, page 80. So in a single day, this was listed and disposed of. That order also is there. That is at annexure 4.
76.
73 at page 75. That is in the case of the Balangi. They have directed, the court has perused the decision of the Supreme Court, Sunshine Limited and so. That is also Mr. Harichandran and counsel, but petitioner placed before the court the compilation several orders relied upon the petitioner, including most recent order of 31st March 2021. This is the Joint Commissioner order passed by the Joint Commissioner of Bhubaneswar. Without expressing any view matter, the court considered it appropriate to remand this matter to assessing authority for fresh assessment proceeding for the tax period in question, keeping the view upon the order. Supreme Court as well as this court 31st March, all the contentious party left open before the assessment. So after this order, the instant case for this is for the dispute in the Katak circle. That is the order 76. So in
122.
70, annexure 5. They dispose in terms of that order also. So in pursuance to that, the assessment order was passed. And this finally it has become nil. It has become nil. So now they have, after this nil order, I apply for the refund. After this nil order, I applied for the refund, which I paid in persons to interim order around 20 lakhs. So they kept pending with them, and subsequently, now they so much power they have now,
And it is appealable.
and only
This revision order is appealable.
only question is that to defeat the refund.
Not over. Taken us to over period orders.
Those for different.
Over period order.
But in promoter resource is now
Under the OST Act.
OSP Act. With the to which period?
That is for 96, 97. Because this Honorable Court was directed to pass the order in the light of the Honorable Supreme Court and that Joint Commissioner order. So in pursuance of that, they have passed the order. That order and that demand is nil. That is, my lord, that is annexure 10. Review that. And what happened? The Joint Commissioner who has passed, already order has been passed. I have raised the plenary.
Demand is not the correct one.
Correct.
Yeah.
So now order has been passed. I have raised the preliminary objection without giving any opportunity. They have passed the order.
Unacceptable.
And apart from that, the officer who has passed the order at the Bhubaneswar as a Joint Commissioner, some officer has sitting over his own order. Now he has passed the revision order demanding the tax.
No. Not his owner. Not his owner. This is against Katak Circle. Sales tax officer has passed the original order. Original order has been passed by sales tax officer, has been so much revised by the additional commissioner. Not the same authority.
Additional same, who is the Joint Commissioner at the time Bhubaneswar, now he has passed, reviewed the order as the additional commissioner. So it is a pure question of law, whether right to use or not.
Different capacity and different order, not his own cause.
As a different capacity is joined, then how will change his opinion?
23 for as like as 79 7 623.
No, against. Your question of law does not mean that the court report displacement because appellate authority definitely take note of the law. He has to say both the fact and the law. He has to be taken. No, against this there is no remedies there.
No, 23 4 C. 23 subsection 4
Madam,
commission.
but there is certain supported, certain judgment is there.
OST rules says that additional commissioner is subordinate to commissioner.
Madam,
Rule 23(4)C. That says if the order in Swanta revision is passed by the commissioner, then it is High Court. The appellate forum. If it is subordinate to commissioner, then it is to the commissioner.
that is not there.
Yes.
Because here commissioner has delegated the power, so there has
OST Act.
23C is there. Any deal, as the case may be,
Still. Other. Who is subordinate to whom?
in the VAT Act that was specific. In the VAT Act that was specific.
This is related to OST.
The OST Act. So that I am telling. No, VAT Act there is a appeal is there against the revision order.
Structure.
Against revision order there is appeal.
But they are confined to OST only. So what to say rule 3?
Open the certificate copy of the order sheet. That certificate, they have to record the decision. What they have mentioned only to block the refund, they have initiated the proceeding. Because rule 80, that they have to show what is the prejudicial interest of the revenue. So all these are already covered by our own High Court judgment are there. So, and apart from the rule of concept, because there are 80 assessments throughout the state, nowhere they have initiated, only because there here refund is there, they have only initiated that. And apart from that, that our own High Court order, with regard to anything which is decided concerning the group program simply reports because of report also that since we have already decided one point. So on the method, it's practice that point will be quite directly. No, with regard to that. Because authority is going to be bound by the decision. And they have to make a decision. My lord, with regard to filing the appeal, I have to file appeal before the commissioner. So already that has been decided. Commissioner has delegated the power to the additional commissioner, and whatever the order is passed, that is as good as the order passed by the commissioner. So our own High Court has told it cannot be revised by the commissioner. Power there. The revision can be done by whom? By the commissioner only or by? He has delegated the power, all power with the commissioner. Commissioner delegated the power to the additional commissioner. So again, I can
Also an assessing authority.
also assess it.
So it delegates all the subordinates. Distributes the work.
My lord, see, in Podar machinery, that has been decided. We are more questioning on the maintainability, not maintainability, interchangeability of the rate. If you say that this order is shall not be treated as an order passed by an additional or a commission. As the commissioner delegated the power, and therefore, if he exercises the power, such exercise of power is by the commissioner. Then also, it is an applicable one and appeal lies to the High Court, it is not granted. Then go and file an appeal if you perceive so. We are more concerned with the rate now, in both ways. If you say independent power, then the appeal lies to the commissioner. If you say no, it will partake the character of an order passed by the commissioner, then also it is the appeal which has to be filed, not the rate. This can be also converted to law. And apart from that, we are from 226 to 227 is permissible. But this is the judgment that once it is delegated, the commissioner has exhausted his power. So I cannot do that. Then file an appeal.
Sir, that commission is not
there.
Section 5 of the VAT Act is not there in OST.
No, I have given this judgment with that OST. So we are saying that whatever is there is a provision for an appeal without specifying where the appeal would die.
That means each and every power has been delegated.
Sir, commissioner delegates power of 12.4, 12.5, 12.8.
Again.
And to the sales tax officer as well as assistant commissioner. Assistant commissioner is also an assessing authority. STO is also an assessing authority. When STO passes an order of assessment, appeal is to assistant commissioner. We suggest that the commissioner having delegated the power
No.
STO for assessment and assessing authority being the assistant commissioner also.
No, here the
And all-
yes.
And all the orders are passed by commissioner.
Apart from that,
Sir.
apart from that, here the order is passed by the sales tax officer, and whether additional commissioner has got.
No, that isn't bad. That isn't bad. Deputy commissioner, if deputy commissioner STO will be passed, then so much revision by deputy commissioner. or joint commissioner. If deputy commissioner or joint commissioner pass, then additional commissioner. That is the notification of 2009 and 18. That is not in OST. That is in VAT.
Maharashtra supplier also question that. Remember, last effort I will show an judgment of my Lord Justice Raman.
That is again under VAT.
That is regarding opinion. The formation of opinion. That alternate remedy is not.
Then I will onwards and say this contrary.
No, this is my Lord judgment. Kindly have a glance. Kindly have a glance to order C. How they are.
Said, in one case, if law is laid down or law is decided. So in each case, we refer judgment to. It is the authority who is to take it.
That is my Lord. That is my Lord priority.
Sorry, that this judgment is binding on you, you can't take a control.
But here their only effort is not to give me the refund. That is the effort. Nothing is there.
Even I, after some,
My Lord, Elvira is there.
I need to refer to medical.
That is
I can refer to individual.
that is also cited. That is cited. My Lord has cited in that miscellaneous also.
Get full.
They kindly allow me to file the delay to be condoned. Because I filed the appeal in time.
Delay तो कुछ नहीं है. Limitation तो नहीं है.
Bottom file करो उसे क्या होना? When you file the delay condonation question, that liberty has to be 1 month because I have received the order on the 31st May, so I have to file the appeal. No outer limit is not there. So I have to give the reason with regard to the spending of the state petition. There are 90 assessment orders throughout Orissa. All are nil. Single year they have reopened the assessment. Only refund.
No, it is a fact also how they have become nil. That is to be looked into. The honorable. Cancellation cover.
The present appeal has been filed against a common judgment. Now, in other cases, we have also filed the writ appeals. Those are not on board. May I pray, my lord, let all the matters be tagged up together. So let the in other cases, we have filed the appeals and giving the numbers.
The lead case.
Multiple writ appeals. My lord.
You have already filed an appeal in respect of some.
Yes.
This is
one of them where this honorable court has condoned the delay. No, delay has been condoned.
In fact, my lord, we considered your lordship to condone the delay because contempt is hanging because they have not implied the contempt.
So when those matters are fixed.
I don't know because in the lead matter, I was arguing the matter. In my argument, I don't know. They have filed.
The lead matter is there, when it is fixed, lead matter.
No, matters are coming Monday. Out of two matters are coming on Monday, where I am appearing.
But four writ petitions disposed of by virtue of the common judgment. Yes. Mile.
You have already filed with respect of 5 or 7. Now, this is one of them.
Yes.
We said 8, 9, 10. I understand.
Mile.
But the senior counsel says that we are going the lead matter. That is what is the lead matter? And when that lead matter is fixed, so that we can fix this matter also.
But this is the lead matter.
This is
the
the
lead
arising
matter.
out of the lead matter.
This is the lead matter.
Yes.
Okay, that's the argument. What?
The argument, I pray, my lord, let all the matters be taken up together where my learned friend was.
If they
Because-
decide, it is decided, it will be covered by that. It will be covering that. That is right.
Involved care for a so and so is being taken up as the lead matter. This is the matter superior.
Yes.
So, pray, my lord, let all the matters.
Point
come
is
together.
very simple.
We will do it, but
Yes.
where is the difficulty in arguing the matter?
There is no difficulty in arguing. Only I pray, my lord, let all the matters be
We
taken up.
go to some pecuniary benefit.
So far as state is concerned.
That's why I have asked.
Based on factual scenario of this case, other cases are disposed of.
Yes.
Then let us do this and
Oblige. Yes.
It will be helpful. If one matter is disposed of, other matters will come on a day board.
let's Mr.
It will be rather easier.
Rock loses
For him also.
some other benefits.
No, my lord, that is not.
What is the matter actually? The fact in what?
Fact, my lord,
Relates to what?
my lord, when the 2015 recruitment rules was in force, a recruitment process was initiated. Now, by virtue of that recruitment process, my lord, a committee, a district level committee was constituted. The district level committee issued the advertisement. Pursuant to the advertisement, the appointments were given. But these appointments were given after 3 years of the advertisement. Now, in between, the cadre rule was repealed and another cadre rule came into force. Now, there were some irregularities which were alleged to be inferred from some paper news cutting, and there was an inquiry by the government, and it was found that the appointments are illegal, and those appointment orders were withdrawn subsequently. So, being aggrieved by that disengagement, they approached this honorable court in the batch of writ petitions. The honorable court allowed those writ petitions where the state has preferred this appeal. This is the only fact of the cases.
The Carter rule means the number of the sanction post was reduced or what has been done.
No.
The Carter rule means what?
The cadre rule, my lord, that
Whereas
is,
that previous cadre rule, also 309 article. Same. And the new rule which came is saved whatever action has been taken. Pursuant
By
to this.
virtue of the material saving law,
Yes.
that should-
In the preamble itself, in the preamble of the new rule of 2019, the same.
When the process of invitation, recruitment was
Initiated, that was pursuant to 15 rule, while 19 rule had not come.
this new rule changed when
19.
in 2019.
is the matter between 2015, 2019.
17 to 19, because the rule was in vogue in 15. Recruitment process initiated by virtue of advertisement in 17. The 2019 rule came into force on 8 March 2019. Appointments were given in 2020. Yes.
But once the process for recruitment is initiated, on the basis of a rule which was really there,
Yes.
then
And the rule of the game started already.
No, my lord, there is no dispute that the rule of game has started, but there were infirmities and irregularities in the process of selection, which was pointed out later.
No, that is nowhere in the
And
record.
inquiry was
Nowhere
conducted.
in the record. Only if your lordship will find out here, they have not given that annexure in the writ petition. Only on the basis of paper clipping. That your lordship kindly see, my lord, that documents. Your lordship annexure 3 seal.
Just thinking of the judgment of the Supreme Court, file number 2 of the primary school. Or the secondary school. It went to the Supreme Court. And the Supreme Court has appealed once the process has started.
I kept other judgments at place.
Usually, when the appointment or the process is completed, it will continue on the road.
No bless, that is.
Even K. Manjushri has been referred to documents and.
K. Manjushri, there is no dispute.
And after 17 months, they continued the job. They are just sacked. Basing upon the government letter. And government letter itself indicates that as per the paper clipping, that your lordship will find annexure 3 series. 3 series. Annexure 3 series of the writ petition.
When the termination came.
Termination came, that is 20. The appointment order is 76/20 and that order is passed on 12/11/21.
Within a span of more than 1 year.
17 months, 17 months.
Your
lordship,
somebody has been without any substantiation, there is no pleading nor a document for serving before the court. What knows what is the outcome of that internal inquiry or a secret inquiry? Something has come out. How can when you have really went through the paper cutting?
Missing on that paper cutting, they had an inquiry. So what is that inquiry? But I have to ask them.
Saying about the paper cutting, does it talk about any kind of a specific inquiry or a special solicitation?
It speaks about the inquiry, man.
No.
Then, can you prove your case for the first time?
And the reference has been given in that letter of the Joint Secretary to Government sent to the CDMO. That reference is newspaper clipping dated 7/9. The lordship can, my Lord Justice Raman is going through that page 24 of the writ petition. And your lordship will get before that 23 is the paper copy. For that, we have been sacked in annexure 4.
Heading is unauthorized, illegal and unauthorized recruitment.
If your lordship can make an inference also, the people, those are not selected, have been aggrieved and made a newspaper publication, then this is the result. This is totally biased net, lordship.
Then you are therefore instructed to disengage all such.
Yes, referring to this letter.
This is against the permanent sanction post.
Yes.
Yes. Permanent sanction first, but the recruitment was on basis of contractual. It was contractual method.
New rule, because the GA department has circulated that all appointment will be given first phase contractual, after 6 years they will be regular. New rule 19 also says that, 15 rule also says. And 19 rule is 309. This is also 15 is also 301.
The amendment is not in that sense. Because all these
Yes.
contractual for 6 years. After successful completion of
6 years, this is regulation.
normally you give
As per 13 rule.
Yes.
Your lordship has dealt, my lord, Mr. Raman has dealt.
Service used to be. If you are making a recruitment or initiating a recruitment process, it could have been permanent something for. Then you can put somebody as a probation period just to understand whether this performance is satisfactory or not. But contractual appointment is that same. And then making that appointment automatically merged into a permanent post or permanent bond. Can you improve your case, sir? Only if the reason is the publication, then can you go and say that?
and you have present during corona. And they have served me much better. During the, it is 2009 to 21.
21, they were disengaged.
Better.
21, they were disengaged.
Category as the
There is eviction. And there are nurses and laboratory technicians, pharmacists, the radiographers, staff nurses.
Here, issue
They are all
is,
pharmacists. In this case, all are pharmacists.
here the issue,
They are pharmacists.
They are pharmacists. Other cases are laboratory technician, radiographer.
There.
Yes, yes, they have served during this COVID time. They have served.
they were pharmacists.
Compassion for these corona warriors.
That time you declared them as frontline warriors. Have you not declared them?
Yes, essentially.
Yes. For them, a rule came into force and they were declared as COVID warriors. And for that, in subsequent recruitment, they were awarded with 5% marks for participation. So that is, these persons, they don't fall under that rule, my lord. That is for subsequent recruitments. But I'll just. only I pray let
Pursue and persist.
only I pray, my lord, let all the matters come next week, so that the other part which fall from law, I can also. I'll just apprise the authorities, because truly speaking, my lord, I could not also find any specific ground to be. Only your lordship may grant me till next week, so that I can the other matter also. And the advertisement itself doesn't refer to the cadre rule of 2015.
Yes,
There is-
no, that report.
Only so far as pharmacy is concerned, your lordship will. Yes.
The essential is done, then the rule which was prevalent must be followed.
Look, my lord, whether that recruitment was initiated in terms of 2015 rule, that is also.
That initiation was bad. So.
Only our counter says it is contrary to the 2015 rule, so also contrary to the 19 rule. That is what the counter says, and regarding that inquiry and other things.
The three judgments are there.
Rejection doesn't keep.
Does, yes.
Wait for para 19.
2013
Then thereafter,
Also there. 2024, 25.
the next judgment is there, 14th judgment.
No, this is on the rule of the game.
Yes, yes. Para 20.
What rule will be the guiding factor? And when the process can be said to have been initiated. And in the event if the rule has been repealed or is repealed by a subsequent, what will be the impact of that?
The law is that also while the vacancy arises and and the rule is prevailing, that rule will be followed.
No, that is not.
There is just opposite. There is just opposite.
And in our state recruitment, the matter had gone to the Supreme Court. That those who claim the doctor's appointment, that since that rule has come, in I think the 2014 rule.
The law is that when they started the process of the recruitment, and on the day when the process was started, the rule which is there will be the guiding factor.
That is the case.
It is not that when the vacancy arose.
Yes, sir, exactly. That is the point.
Says the in reverse. In Kandikara, it is reverse. That was the only point there. That whether the rule prevalent at the time of vacancy will arise, will apply, or at the time of initiation of the process of recruitment to the
Initiation. Here it is a case of initiation.
Rangaya has been reversed in Rajkumar. Rangaya has been reversed in Rajkumar, but that is a case of promotion. It's not the Rangaya case reversed in Rajkumar, but Rajkumar is a case of promotion. There the Honorable Court held that if once you are an employee, you are bound by the rules which is framed by the government from time to time. And the promotions are to be made on the basis of the rule which is prevailing on the time of consideration, not at the time of vacancy. That was the judgment of Rajkumar.
On the time when the process is not issued.
Yes, on consideration, when the consideration for promotion, that is why it said promotion, because the DPC, when the DPC is held, and the rule prevailing on the date of DPC has to be. I pray, my lord, that all the matters come so that I can also go through the judgment my lord is referring to. I can also go through that. And
They are not, you are not
it's no
allowing
question
them.
of delay.
That's why
It's
the
already
contempt
been
is
delayed.
there. What pleasure he gets there.
Tarun Kumar Majumdar. Tarun Kumar Majumdar is the state of West Bengal and others.
Salinagar, School.
Is it my lord versus Archana? Is it my lord Anand the boss? Anand Biswas.
State of Calcutta. It's about,
This is about Kalinagar that is referred. I think who would certify?
citation तो देंगे उधर मुझे आनंद विश्वास and others with state of
Anand Biswas and others versus state of West Bengal.
Ashok Sahu is also will be another.
State of West Bengal. The staff of Kalinagar Junior High School.
That was the consideration which was prevalent. Anyhow, that was it. I believe so. Because the two or three enlightenment has to be on the right side.
Archana Ghosh.
You have to say, first thing is, when the process of recruitment commence, then the rule which was prevalent, that will continue. And the subsequent rule will not be applicable in that regard. This, irrespective of the fact that the appointment was made when the subsequent rule has already gone. It has got no relation. Second, the termination solely on the ground of the newspaper report without any discrete inquiry or affording an opportunity. That is also not permissible.
I'll address on that. And all the matters come together and.
This is the judgment your lordship considering. This is the judgment. The common judgment. And my learned friend is there in the other side also, in the other case.
I know it because there are multiple judgments, there's some of them, somebody will have a problem, that's why I want to take one matter.
Yes, yes.
And finish it off.
Yes. Later my friend gets, they went to lingering the matter.
What lingering?
I'm not praying for lingering, just praying that all the matters come together so that even other councils.
In first paragraph, I will kindly see. First paragraph of the rules, saved matter, you publish matter. The first paragraph of the 19 rules says, the thing which has not completed, there that in that circumstances, old rule applicable.
No.
In first paragraph of 19 rule.
Preamble.
That said that the thing which has not completed, so they have to, so that is why in 2015 rule, our business has been prepared, were selected. Except
My things done and
omitted to be done. Omitted to be done. So we are saved as per 2015 rules, man.
That has been reported by the
But the preamble, the interpretation of the preamble would be, yes. Things done and omitted to be done. So things done means things which has already, recruitment is over.
My
Yes.
we have given the picture.
Then you can argue, this still has to add other matters, but
On Wednesday, next Wednesday, you can also fix it. Yes, yes, I'll have.
Let's fix a time so that it can be. Top of the matter or 2 p.m.
They don't.
That's the point of.
They don't.
It is eventuality what happens. In 30 or 10 September. Yeah. I'll back of the. And I am for the appellant for a few weeks time. Let me look for getting myself prepared with the judgments of. Yes, so another case.
For the respondent number 4, a similar kind of matter has already been disposed of by this court in the document number 95 for 2025. The only difference is that in that case there was a criminal disciplinary proceeding has started against the respondent number 4 in that case. Here some amount of loan she taken and not paid, that is why her gratuity has been denied. It's the only difference.
She has not cleared the loan and she stood guarantee for 2 loans. So that has not been cleared. But that was the loan was sanctioned. They are also the employees.
Petitioner is a very old link. It's very old bed. Petitioner is now, sorry, petitioner respondent number 4 is of now bedridden. She has brain stroke. I think she's 70 plus most please. Because she retired in 2010.
Item 32. Item 32, SGI was appearing in this matter. Date may be fixed. There is one. Madam. Then to 22nd September. Published. Then 33. Mr. Mohanty, on day. Then to 11 September. Then 34. 54 you have already had this matter on 16/7. The was completed.
What is this matter? Just can you recapitulate?
That land was encroached by this opposite party number 827. The encroachment proceeding was completed. They did not vacate. Was passed. Yes, yes.
Then
When the government,
before this court.
pardon? Yes. Then,
That issue.
as the judgment was passed, directing to evict them. Government also ensured that because of non-cooperation of the police, we have made requisition to the police and soon after that is done. These opposite parties, because the encroachment cost was finalized, till then they did not vacate. They were not made parties. So they carried to the, and however that order was challenged in the apex court dismissed it. They had filed. However, then they filed a review petition in this honorable court. This honorable court allowed the review petition, added them parties and opposite parties number 8 to 27. They have also filed the counter, their everything. And the government was also called for by the previous division bench that you state the status. They have also
They went to the Supreme Court against the criminal.
parent.
What happened to the?
That was
Review with liberty to go for a review or what?
no liberty was given. No,
This was one line.
they had gone to the Supreme Court.
Who has gone?
That means those who are made party subsequently.
Correct.
8 to
That
20.
is what I really wanted.
Yes.
Oh, taken on board and dismissed.
Yes. And given passed on a bunch of orders.
So, this order of the review application was allowed.
Review application was allowed, filed by them, by OP number 8 to 20. They are made party. They are made parties.
Sir,
The rest,
in matter is pending. In matter is pending.
main matter is pending, that is why your lordship had that matter on 16/7/20.
What?
It was hard.
No, what is?
Oh, sorry. It was hard. But then your lordship will file the counter affidavit. It was called for from them that what steps you have taken. Then government has said that yes, these are the status has been given. These people are encroaching this land because these areas are required for the development purpose. So then the government said that we will make the requisition police and then will evict. So that is how this is the process. And if you will find that
In 20 encroachments, final order has been passed, my lord.
pardon?
Encroachment proceeding terminated into an order of removal,
Yes, completed.
but they could not execute it.
Yes. And it is a vast acre of land. Vast acre of land.
We have approved the district to provide sufficient police force. But because normally the serious law and order arises at Chilka area, my lord.
There is a central process which is also available. Because the police is inactive in bad things. So let the central forces, CRPF or something, they will go. Because the police is not very efficient enough to support.
Your lordship may direct so that
No process has been undertaken, but our case is that we are not made party in the writ application. They have made allegation.
Who are you?
We are encroached by it. This is a PIL. My lord, this is a PIL.
Proceeding is initiated.
No, my lord.
Interesting. They have initiated.
My lord, let them do. My lord, our case is
Encroachment
that.
cases are listed.
My lord, this
That
is
is
a
there we have given.
My lord, this
These are the
is
table given.
my lord, they are also.
We had argued vehemently on that day.
They will also go.
My lord, they are also encroachers.
Yes.
And they have also written to the collector that their signature has been procured.
Who has said?
That in the list or
That day your lordship kindly recollect, your lordship said that whoever may be there will be evicted.
I have specifically stated
No.
all are encroachers. They are collecting money. Government has not adopted the process.
Government has
Adopt as per law, they will, but
initiated the encroachment.
no, nothing minor. No, that they have not filed counterbury. They have not filed counterbury after review it, already reviewed. The
My
court
lord, affidavit was called for from the Tahsildar to give a report as to how many encroachers are there. And but collector at TTVT giving an affidavit, giving the list of 20 persons who are encroached upon the land. And the order of eviction has already been passed against them.
After review.
Now, we have asked for police force for him.
No, what?
Where is the affidavit?
Affidavit is there, my lord, is filed here.
Affidavit dated 16/8/23.
16/8/23.
Flag C.
Flag
C.
Annexure 1 is the list of the encroachers.
This is pursuant to the order dated 12/1/13.
This flag.
C.
Annexure A, flag.
Flag C.
My lord, I want to receive the copy. The affidavit. No copy was served.
Police to These two have encroachment.
My lord, I have not-
33 encroachment cases we have given the list.
I have not received the copy.
You are not, don't rely on me, but whatever they have admitted in the affidavit will go. And we'll say that whoever.
My lord, let it, my lord, it is massive. This is a massive growth. My lord, this is, against all, against all, not in selective matter.
Initiation proceeding completed, they have not prepared any appeal, nothing is there.
Not 33.
And encroachment cases numbers we have given. Also, they have also given in the report.
I have stated that 400 encroachments, that is a massive growth
33
of encroachment. Direct the government to adopt the process of law.
3.5 acres of land they have encroached.
You have also encroached.
All right, will be evicted.
No,
No problem.
I specifically stated.
Both are to be evicted.
Everybody, not both. All may be evicted. Not by selective method.
All will be evicted. Who are in encroachment, they are to be evicted.
Yes, they.
If you have not initiated against some, you have to initiate and.
Yes, this is welcome.
Long back file. Easily file is. You came now, na?
No.
File is
Suppose 23 time file kar chuna hai to.
Someone has.
That's it. May kindly see Annex 12, 33 encroachment cases.
That is your prayer is, but they have not admitted. But what we say is that without going by the number, we will say that first thing is that they have disclosed that they already issued a notice. We passed the order for eviction, but because of the police who is not rendering the adequate number of the police personnel, the order could not be executed. For that, the mandatory eviction will be passed to immediately execute.
Oblong pass. Yeah, and
Further inquiry will be made, shall be made in respect of any government matter where any encroacher is found. If any encroacher is found, then immediately the proceeding has to be.
Yes.
It will brought to its conclusion and then.
Yes. Most welcome, man.
And
Grateful to your answer.
Even the police is not really adequate enough, then we are directing the CR. Where is the DSG? So if you can give us the adequate personnel from the CRPF or you can go to the military also.
Your Lordship can pass an order to the collector Khordha to provide sufficient force.
That will,
Collector will provide, or it is the SP who will provide the police service. You will simply make a requisition to the police department to provide a adequate,
already requisition made to police department by the Tahsildar man.
what?
Tahsildar has already made the requisition, and because of some problem, they are not provided sufficient adequate.
Problem is something else. The problem is something else.
Go to the SP and collector, your lordship may direct, so that.
No, we will be directly, can anybody contact the London ministry? So that we have to say central forces to correct.
No, you can come first. Yeah, yes, central government council. Yes, sir.
This is a letter of the.
Central forces here. Can you not provide those central forces because we find that this is very inactive?
If the requisition made by the.
Not necessary, by us.
Yeah.
By us. And we record that the police is not very insensitive, not capable of providing the adequate assistance to them to carry out the order. We record that. And then take an assistance from this. Will you do, Mr. Government, I repeat?
Your lordship can observe that Tahsildar has already made a requisition for police force, but that not provided, no CRPF will be.
Say that means that there is an apathy, there is a complete, the stubbornness which is shown by the police administration, not providing anything.
Your lordship can also.
Yes. You have adequate number of battalions here, here.
Battalion, the Odisha battalion is there, but I exactly.
Which, this is the Chilpa, which place?
That is near to Bhubaneswar. The naval center is there. The naval center is there.
CRPF.
But in that area, normally, my lord, serious law or adoption arises. In the past accident, said when the gheris were removed from the Chinka area, there was serious land. Gheris.
And to catch prawn.
The prawn gheris.
It's called a gate.
Prawn gheris.
Because the Supreme Court has said that there will be no culture prawns, only capture. But they had put that unauthorizedly. That is why those were removed.
Surveillance drone, is it functional? In PIL, I was party to that judgment. Where we have.
I have not seen that matter.
For collectors, Chhatrapur, Puri and
Kendrapada.
To have surveillance through drones with regard to
The
their.
lordship can see the inaction from the letter right annexed 12, wherein the Tahsildar is giving a letter to the sub-collector Khurda. I am reading the concluding paragraph. Hence, to make the eviction work success, it is further requested, kindly look into the matter, and the matter may be discussed with the Superintendent of Police Khurda for early deployment of the platoon police force with the lady police constable to carry out the eviction.
Yes,
Proceeding under the under nothing.
We are not going to pass an order or a direction. Where the proceeding according to the state administration.
Initiative. Nice.
We will carry out those orders.
In accordance with the OPLE Act,
We don't know which are in accordance with that.
My lord, in accordance.
And the encroacher who
My
has suffered an order
My lord.
will also respect the law.
My lord, that will not process of law, due process of law.
They will act in terms of the law.
My lord.
And the person who is
My lord,
who has suffered
that is there.
respect the law.
My lord, that is always there.
What I mean,
My lord,
respecting the law,
I know.
no ruckus to be created.
My lord, no ruckus is created.
Not
My
to
lord,
delay
this
the
is-
matter, Lord,
My
I
lord,
kindly fix the
this
time
is a
bomb.
massive
Time
growth
bomb.
of farmers' possession, my lord.
There is-
And
Yes, we want-
more than 30 years. School, colleges, hospital, temples, everything has been established. It's not a small growth, my lord. 400 and closer, 10,000 population, my lord. My lord.
Sir, Mr. We are requesting to finally implement DSGI on present in this matter. On previous matter. Okay.
My lord, I have one request. Today I am talking to the SP Khurda. I am taking stock of the situation what has happened to the requisition that was sent by the Tahsildar to the sub-collector. But let there not be any observation that state police was not able to do because there is lack of it. That is
Record.
I am talking to SP today and your lordship take the
Yes.
I mean,
You also take a decision, I tell you, you also take a decision. whether
Yes,
they
ma'am.
can provide. You also take a decision, whether you can also, central forces can also teach.
Your lordship, single.
Then on whether, we'll see.
by joint effort of
Say
state
that,
police and
yes,
CRPF. Man.
then we will not bother you. In the event, is still they are
My
so,
lord.
so much of, the resistance comes, then we will interest.
This may I seek your lordship's indulgence. Item number 40. My MSME unit, this matter has been rolling in the list for quite some time. My lord, sir, it's a matter which is under your lordship's my lord, your lordship, in fact, yeah, I know. Indisposition is something that is beyond our control, my lord. So that
Item 46, interim order.